Today, our speaker is very knowledgeable. He's been with the Birch Water and Sewer District since 1998. I guess that doesn't qualify him for anything, unless he has been. Prior to that, prior to Birch Bay, he was with the Seattle Engineering Department for over 10 years. Prior to that, he spent 7 years with the Greater Federal Way Water and Sewer District. He has a master's degree in public administration from the University of Washington. That also should not be held against him. In addition to all this, though, he has spent a considerable amount of time with state water issues and is extremely knowledgeable regarding these matters. Here now, for our enlightenment, Mr. Roger Brown of Blaine Water and Sewer District.
We're in the vicinity. Thank you, Greg. Okay, how's that? I am the manager at Birch Bay Water and Sewer District, and also since 1998 have served as the Water Districts Caucus representative to the WRIA1 planning unit, which I don't expect to make any sense to you at all, but maybe as I go through this I can fill in the details and you'll see where that fits in. I'm going to want to talk about some water issues. Like Greg said, I think we're headed for litigation over water, and I think it's happening in a way that's not in the public interest. I also want to talk about some issues currently before the county council. But before getting to that, I need to cover some planning processes that have been underway for some time, because these issues emerge in the context of those planning processes. So there are three related processes I want to talk about: the Endangered Species Act, listing of Puget Sound Chinook and other species, watershed planning, and salmon recovery program. The latter two are state enactments, and the first one is federal. The Endangered Species Act first. In 1999, Puget Sound Chinook and other species were listed as threatened. When that happens, you have to have a recovery plan. That's the federal law. And then that's administered by a federal agency. In this case, most of the action occurs with National Marine Fisheries Service, or NMFS, so that's what I'll talk about, just to keep it simple. The recovery plan established two goals. One is delisting of the species, and the second is to obtain a harvestable surplus of fish in conjunction with restoration of meaningful exercise of tribal fishing rights. The first of those relates to the Endangered Species Act itself and pertains to wild fish, or the evolutionarily significant unit. The second pertains to the federal agency's interpretation of the federal trust responsibility relative to the tribes, and that can be primarily met with hatchery fish. So how did they go about doing this? They developed something called the shared strategy. Called it the shared strategy because normally the federal agency defines the recovery plan, turns it over to some other unit of government for implementation. In this case, NMFS shared responsibility with state, local, and tribal governments and stakeholders. So it was called the shared strategy. Shared strategy, in addition to being the name of the overall approach, also was a nonprofit organization, in this case, called Shared Strategy, which in 2008 became a state agency called the Puget Sound Partnership. I think that's interesting, and it's unusual. I'm not sure what effect it has on anything, but you'll hear about the Puget Sound Partnership as we go. And that's where it comes from. It started as a nonprofit organization. The strategy also was very much based on local initiative. Planning was to be started at the local level, develop regional decisions and regional plans. There were a number of regional plans developed, and these were to be elements of a mosaic that included all of the regional plans. Then there would be a state plan, which was kind of a layer, and then the federal layer on top of that. That was the scheme for how they were going to do it. Here are all the different planning areas where regional plans were developed. And then a statement out of the salmon recovery plan itself. Local communities are the essence of success. Local watershed efforts will lead the region to recovery. And then it cites the two state enactments that I mentioned, the Salmon Recovery Act and the Watershed Planning Act. The Watershed Planning Act came out in 1998, RCW 9082, administered by DOE and organized by something called a WRIA, which is a Water Resource Inventory Area, and that's DOE's administrative classification. We are up here in the northwest corner of the state as WRIA1. Well, the way it was implemented here was that the initiating governments established the planning unit. Those things are in quotes because they're terms out of the statute. The WRIA1 initiating governments included the county, Bellingham, the PUD, and the Lummi Nation. And by a memorandum of agreement in late '98, the WRIA1 initiating governments agreed to establish the planning unit, which they did. And this is what it looked like. There were two types of entities. There were governmental entities and then interests. The water districts appeared as a caucus among the governments. That meant that there was one seat at the table, and that person at the table represented all of those other parties. I represented the Water Districts Caucus. That's 10 local governments, but we had a seat at the table. The way it worked was the planning unit established its own procedures, and one of those was a decision-making rule that required that major decisions had to be made by consensus of the governments. That meant, from my standpoint, the water districts had an important role. We had to be involved in every significant decision. We directed the planning process, approved the scope of work, finally approved the watershed management plan and submitted it to the county for approval. And it was approved in June of 2005. It called for negotiations on in-stream flows. That was one. There were a lot of things in the plan, but the one I wanted to highlight was that it called for negotiations on in-stream flows, how much water was going to be required to be in streams. Those negotiations were confidential. If you weren't at the table, you couldn't find out what was going on. They involved the tribes, Bellingham, PUD, and others. And then they were supposed to report back to the planning unit with preliminary results. And that way you maintained the consensus-based planning process with all of the interests at the table. We were also supposed to approve watershed management plan updates. The adopted watershed management plan has significant weight in the statute. The adopted plan is supposed to be the framework for DOE's future watershed decisions, and DOE has to rely on the plan as a primary consideration in determining the public interest. And as I mentioned, DOE can't approve any change to the plan without actually going all the way back through the same kind of planning process as was used in developing the original plan. In salmon recovery, you had that also in 1998. That's RCW 7785. Same kind of concept, I guess, in terms of a locally driven process. Here, the county was the lead entity. They established a Citizen Habitat Committee, and the Citizen Habitat Committee was charged with proposing a project list. They came up with what was called the Salmonid Recovery Plan in June of 2005, same month and year as the Watershed Management Plan. Interestingly, at least I thought so, that plan, I didn't know this at the time, but it called for recovery to 80% of historic numbers of fish. That sounds to me like a lot of fish. That would be 4 years out of 5, you have the same fish runs as you had in 1810 or something like that. I'm serious. That's what, to me, that's what that means. I mean, I haven't really made a study of it, but I just say, it sounds like a lot of fish. Most people agree with me when I say that. Where did that come from? And it has to correlate with water in some way. It's not clear exactly how. So how do you put these things together? Well, all the plan says is that it's deferring to, that the salmon recovery plan says it's deferring to the watershed management plan for the setting of in-stream flows. But there's an unresolved tension here, I think. This isn't something that I knew about at the time. I don't think I read the salmon recovery plan in 2005. Well, there were problems as we move forward. Stakeholders, persons and parties who've been originally involved in the process have been excluded. What do I mean by that? Well, first thing is the WRIA1 joint board. Remember, there was a memorandum of understanding under which the initiating governments formed the planning unit. They were the county, the Lummi Nation, Bellingham, and the PUD. Shortly after the planning unit got underway, those same parties, which by that time also included the Nooksack tribe, entered into an interlocal agreement calling themselves the Joint Administrative Board, which was shortened to the Joint Board, and they were kind of providing oversight to the process. They made decisions by consensus. That was something I knew about. I didn't think too much of it, frankly. It seemed like you needed some kind of executive entity to drive the process. In retrospect, I think it should have been the county, but it seemed like that was the attempt to give something, or to create something with executive force to drive things. In the salmon recovery area, there also was a policy board formed. The Salmon Recovery Board became the lead entity replacing the county in this side of the process. The membership there was the county, tribes, Bellingham, the small cities, Fish and Wildlife. And they also made decisions by consensus. These three parties, county, tribes, and Bellingham, were members of both boards. So at some point, maybe they thought it would be efficient, I'm not sure, they decided to get together. And they met first in July of '09, and when they sat down and met, they agreed that they would continue to meet jointly with agreement by consensus. They also agreed that they would reduce the role of the planning unit, which was a more broadly organized entity, and it would be retained only to review in-stream flow recommendations. But in fact, there have been no meetings of the planning unit since June 30th of '09. So in over 3 years, it just hasn't met. So effectively, they put the planning unit out of business when they started up. In 2010, they proceeded to develop a new plan, which they called the Lower Nooksack Strategy. And that wasn't communicated widely. It wasn't something that ever arrived on my desk that I heard about. It was a $2.6 million 5-year plan that it included elements that had been planning unit activities under the original plan. It made no mention of the planning unit, and we contend violated the watershed management plan and the related statute. Later that same year, they went to the Puget Sound Partnership, which had originated as the shared strategy nonprofit organization, and had themselves designated as what is called the local integrating organization. They're active right now. And one of the key functions they have is to advise the Puget Sound Partnership on funding priorities in WRIA1. So they're in a position to direct funding to the projects in which they have an interest, such as the natural resource marketplace, for example. That would be one that they would have an interest in, and that they do. They also got the county to appropriate funds to them in September of 2011. And it was the month before that, I think, that I heard this was going on and felt like somebody needed to raise some kind of objection. And so we began to raise objections at that time. And I think it had the effect of keeping that money from ever being allocated in contracts. So it was appropriated, but I don't think it's ever gone forward from that. So to recapitulate, you have these two planning processes. In each case, you have a policy board, and they coalesce into a consolidated board. But that drops out quite a large number of interests who had previously been involved. Decision-making is now concentrated in this consolidated board, and all these other interests are left out. So our position on this, which we've been communicating to DOE and the Puget Sound Partnership and the county, is that stakeholders have lost representation here. It violates the plan and the statute, and there's a lack of due process and equal protection. And those are positions that the Water Districts Caucus has communicated as a group. So one of the interesting things, I think, is why is this happening? The water districts are 10 local governments. We comprise 16.7% of the assessed valuation of the county. We have 17,000 registered voters. We're large enough that would seem to matter. So why would one drop those interests from the process? In my opinion, it's because as time went on, the process changed from being something about enhancement of fish populations to something that is related but distinct, which is control of water itself. There's more power and economic value associated with the water itself. And when that happened, the big players wanted to make changes to the process that gave them greater assurance that they were going to have a decisive influence over the final results. And it also implicated or implied that we were going to court. The only place you can resolve the allocation of water is in court. So we now have pending litigation. So to explain that just a little bit, in Washington water law, waters of the state belong collectively to the public, owned by individuals or groups. You can obtain the rights to use the water. That's called a water right, subject to certain considerations. It's administered by the Department of Ecology, and one of the fundamental principles is the prior appropriation doctrine. First in time, first in right, meaning water rights are awarded to the party who first duly appropriates the water. One exception to that are rights that the tribes obtain, though, through treaties. That comes outside the framework of state water law. The tribe may obtain a reserved right through a treaty, provided that water is related to a primary purpose of the treaty. And then when they obtain the right, there are two ways they can obtain such rights. They can either be consumptive uses, such as use for domestic purposes or agriculture. In that case, the priority date is the date of the treaty. If it's for an aboriginal use, like fishing, then the date is time immemorial. In either case, it's for just about anybody else. In 2011, we found out, we didn't know this at the time it occurred, but we found out that the Nooksack tribe and the Lummi Nation had each requested adjudication of tribal claims in federal court. They sent a letter to the department, or letters, they're worded exactly the same, but they sent letters to the Department of the Interior at two different times that year.
How are you going to ask questions later, or can we ask them now?
I prefer that you wait until the end, if you don't mind. Thank you. The letters to the Department of Interior, those petitions, very importantly, assert a homeland right. And that is a big deal. It was, the homeland right was described in federal district court as a water right for a broad and almost unlimited range of activities. So you could assume it might be as much as control over all of the water. It's a lot of water in any case, and it includes an in-stream flow within it. It's the in-stream flow plus a significant amount of out-of-stream use, and they separately assert an in-stream flow right. Well, what are the implications of this if they're successful? Well, the tribal rights are going to come before any other rights, and they'll come in front of the existing rights that have been granted since 1855, and any new rights, which I would think not generally be possible. The good part of this, from certain standpoints, is that the tribal in-stream flow rights would result in abundant water for fish purposes of various kinds. But as I said, they would displace existing rights over a large area. So that is going to be contentious, and how do you resolve those problems? The only way is through a process called adjudication. So the tribes are correct in the sense of demanding an adjudication to address their issues. The only place they can be addressed is in court. An adjudication is a legal proceeding that determines the extent and validity of existing water rights. And it's the only method for giving legal certainty to water rights. The term general adjudication refers to an adjudication that addresses all of the water rights within a particular water system. One of the major pluses to adjudication from my standpoint is that the court has to assure that all interested parties are heard and that everyone gets due process. That's meaningful to us because we've been left out of the current process. Our place at the table has been taken away. So that's a good feature to that process from our standpoint. Also, the court does encourage negotiated settlements. You often, in the discussions of adjudication, hear adjudication described as if it excludes the possibility of negotiation. It doesn't. It's actually part of the process and is actively encouraged. The difference is the negotiations occur under court supervision, so you have a referee. The key issues that are going to have to be decided first is the federal court versus state court. The tribes are looking to go to federal court. That is not mandatory. That's a choice, and it has to be itself, I think, probably litigated. And that's something to think about if you do want it to go to state court, which I think is in our interest to have it be in state court. The tribes' issues would be addressed first due to the seniority of their claims. And then the fundamental questions are going to be first, what are the primary purposes of the reservation? And then what water quantities are associated with those purposes. The question of state versus federal level pertains to something called the McCarran Amendment. That's a 1952 federal law in which the federal government waived sovereign immunity in states' general adjudication of water rights. An example of that is the Aquabella case in Yakima. There was a big drought in 1977, lots of conflicts. The Yakima Nation filed suit in federal court to determine their water rights, and they got that going. And then later, the Department of Ecology came in and initiated a general adjudication and moved to remand that litigation to state court. Here's a copy or an excerpt from the 1977 motion to remand the ongoing litigation from federal to state court, citing the McCarran Amendment, and the case was in fact removed to Yakima County Superior Court. this big blob right here. That's the it's a 4-county area. It's not all of 4 counties, but it's all are part of 4 counties in eastern Washington. A very large case, the largest adjudication ever in the state. So the McCarran Amendment has significant weight to the federal court. It has to be a comprehensive litigation. It has to be a general adjudication in state court to have that occur. Here's a statement from the Supreme Court. Their basic philosophy is they're against piecemeal adjudications. They like to see something done that's comprehensive and deals with everything in one suite of activities. So based on that, there's some reason to think that if you had a general adjudication properly designed in state court, it could happen in state court. These are just, this is a Supreme Court citation on that primary purpose issue, where water is necessary to fulfill the very purposes for which a federal reservation was created. It is reasonable to conclude, even in the face of Congress's express deference to state water law in other areas, that the United States intended to reserve the necessary water. But they have to show that there is a primary purpose related to that water use, etc. Well, this is to me interesting. The tribes are saying they have a homeland right in the treaty, and that's a large demand for water, and they're saying that comes from the meaning of the Treaty of Point Elliott. This is an old map of the Treaty of Point Elliott. I don't know if you can read it from out there. That's New Whatcom up there, where Bellingham is the only one I could find of this. But the area covered by the Treaty of Point Elliott starts at the Canadian border, goes out into the Georgia Strait, down through Puget Sound, loops around Vashon Island, and dips down into Pierce County over to the Cascade Crest and back up. So there are a large number of properties that are going to be involved by implication in litigation, let's say in the Nooksack Basin, because the tribe is going to have to make arguments in court that justify the allocation or the determination that they have that there's a primary purpose to establish a homeland for the tribes in the treaty. Well, that would be true of all the other tribes too. So it would apply to all of these properties. So the litigation is going to be extensive in terms of the interests that come to the table. So I'm saying it's a big deal. There were 4 or 5 treaties passed or approved in 1854 and 1855. Medicine Creek, Point No Point, Nia Bay, this one other one. They all have almost exactly the same language. So it's not even going to be limited, I think, to the territory covered by the Treaty of Point Elliott. I think there'll be lots of interests who come into that litigation. Once you determine, for example, that maybe there would be fishing rights or fishing as a primary purpose of the treaty, then you would need to establish the water that is associated with that. By determining in-stream flows, that would be another very controversial issue in the litigation. There are significant unknowns about what flow conditions are needed. That's a statement right out of the Salmon Recovery Plan. Courts have not developed any single methodology for doing this. They're kind of resource questions. You have to bring expert witnesses to court to defend different points of view on these matters. This is a statement that concerns me. This is out of the tribe's petitions. They're saying that analysis performed by Utah State University provides the best available science on in-stream flows, and that the amount of in-stream flows required are significantly greater than what the state has established by rule. Well, what this is referring to is the fact that In 2002, the joint board, I mentioned that earlier, the joint board got rid of the United States Geologic Service and brought in Utah State University at the behest of the tribe. They preferred USU to do this work. And they succeeded in having their point of view sustained. And they came in and produced results that did greatly increase the amount of water required. As part of what I've done, I briefed a group of farmers at Farm Friends, and one of them said that his understanding was that the amount of water that was required was more than all of the water in the stream under this standard. So it's pretty impractical. And then there it sits. It's evidently part of the work done under the watershed management plan. I think it needs to be re-examined. There are two approaches to the adjudication currently being talked about, as far as I know. Maybe there are more I don't know about. But this is the lower Nooksack strategy. Don't worry, I will not try to explain all these boxes. But this is designed to come up with a watershed, a water plan. It's under the policy direction of the Consolidated Board. I've already said why I don't like that. The negotiations, when they occur, will once again be confidential with no court supervision. It leads to federal adjudication, and I've objected already to the fact that it violates planning documents, RCW 982, etc. So the alternative is a general adjudication in state court. To do that, you petition DOE. The statute provides for that. I won't go through all the details, but they have to react to that. It becomes kind of a budget question for the state. It has significant advantages compared to what is currently being contemplated. Equal protection and due process are assured. Legitimately interested parties cannot be excluded. There would be court supervision, so there would be external pressure to reach conclusions. The review would be comprehensive. Very importantly, the adjudication could take place in state court. So the magistrate and the trial court would be an elected Whatcom County judge. I think that's in our interest. So we're thinking this is the process that does the best job of giving everyone a fair access to the process. I said I'd end on points for the county. What are the county's interests in this? The county has never really wanted to take a lead role in this throughout the process. The county's interests are that existing rights and uses may be reduced or extinguished depending on what happens. If that is the case, land use designations could be undermined, would be undermined, and economic activity would be dislocated, and their property and sales tax revenues would be reduced. We believe the county has standing, meaning they have standing to enter litigation. They have the kinds of issues I was just talking about. Those are at stake for the county, so they can go to court to protect those issues. We're thinking that they should. I won't go into the details here. These are just some land use policies that tie water to land use decision making. I think that's pretty clear. They have a separate policy on farmland preservation. It also implies you have to have the water to make that work. So the points we've raised with the county since August and also recently are that we think we're headed for litigation, so the county should be preparing for litigation, and the most fundamental thing they should do is secure specialized legal counsel to advise them. We think they should reconvene the planning unit. The planning unit should take another look at some of these technical issues that we think provide the underpinnings for the litigation, and then enter the litigation. This will also cost money. We think the county has a dog in this fight, and that has funding implications for the county. So we're saying they need to figure out what they're going to do and develop a plan to fund it. That's it.
We have about 20 minutes for questions. I need to remind the audience, because I know you want your questions. the members' questions come first. So we will try to get to your question. I don't believe, oh, you are a member?
No.
You're not a member, that's what I thought. So I'll let you go ahead and choose your person, the name. Will you choose them?
I don't know who the members are.
Oh,
Start over
Randy,
here.
we'll start with you. Stand up and give your name and question.
Randy Elmore, member, and can I defer to this woman? I think she has an important
Sure.
question. And
I'll let that
ma'am,
happen.
please.
I got two things.
Notice Dickerson.
Do prior rights go back how far? You know, you got
I don't know.
older lawyers with experience, and you've got some of these upstarts that think that they want to divide what are artesian water and the regular flow out of the same well. How do you do that?
I don't know.
All right,
Okay.
that's what I want to know. And this older, more experienced lawyer group have tried to substantiate the prior rights thing. But you've got a whole bunch of these younger upstarts that are in on some of this later government stuff. And we're in it. Our artesian well has been affected by the town of Ferndale getting back into this well business until we no longer have an artesian flowing well. Okay, they pulled this once before, so we've got a group going. So we're going to try to get Ferndale out of our aquifer again. And it makes me so mad that they don't, you know, prior rights, we old people, shoot, that made our valley nice was having good water. Now, the town of Ferndale, with all their hierarchy and everything, think they can just upset our whole apple cart. This is ongoing today.
Sure, thank you.
Bill?
Hi, Bill Geyer from the Bellingham. Appreciate the presentation. You took a thesis and put it into 30 minutes of direct information. So I thought it was very on point and direct. My question is, have you secured opportunities to make the same presentation to the other bodies of elected officials, such as the County Council, Bellingham City Council, the other 7 cities, etc., or 6 cities, excuse me?
Well, I did this originally because I needed to brief the water district boards. I have a responsibility to do that. When I found out about the Lower Nooksack strategy and this was all going on, we reconvened our planning unit group and then wanted to talk to the boards. And there were different people on the boards from 3 years prior, so that was the initial focus. And I have briefed a group of farmers at Farm Friends, and I did brief the county council in August, and I briefed Ferndale at their invitation, and then some individual staff. I was invited to the BIA and briefed them as well. So it's just been, if people ask me to come, I have.
Follow-up. My point here, of course, is evidence before elected officials that they are then participant in this process. And if you're on record, as you may well know, simply a 2 or 3 minute on record with the county council does one thing, but if it's the full presentation of an audience to look at this and discuss it, I guess that is the focus of my question. Have you had that opportunity to secure that level of presentation to all of the elected bodies in Whatcom County?
No, I did it.
Is that something you'd like to pursue?
I've done something like that with some of the water district boards, probably most of them, and the county council. The county council had me on for a half an hour and 15 minutes of questioning, and it was, I think it was pretty well understood and received, but no, I haven't covered everything.
Let's go to Chris next, and then Bruce after that.
Are you familiar with Carciera versus Salazar?
No.
Carciera versus Salazar is a federal case that was, they won, and it said now means now. In 1934, the Indian Reorganization Act allowed existing tribes and reservations to reorganize. In 1934, the Lummi Indian Reservation signed off and said no, they do not wish to be part of the Indian Reorganization Act, as well as the Nooksack tribe was not a federally recognized tribe at that time. Are you going to get informed on this in using it with your case here? because there's a signed document. Marlene Dawson has it, I have a copy of it, that says that they did not want to reorganize, that all of their land had been allotted out to the individual Indian families.
There's a resource question here with me. I've got my own job to do, and I've tried to put this information out in a reasonable form to the extent that I can. But what most important thing I'm pounding away on now is we need to get attorneys. You know, I'm telling the county that. I've told the water districts that. The water districts still haven't done that. I think that the point is appreciated, but we have an organizational issue. It's not that easy to hire one attorney for 10 local governments. And we're going to our state association next week to talk to them about it because we think it has very broad significance and we might be able to bring them in. But what I really need is another layer of resources. And that's what our attorney tells us, too, is consistent with what he says. So in terms of some of these other things that are no doubt extremely relevant, that's why we need expert legal counsel. And we need a way to spread those costs over as broad a base as possible so they're affordable. That's the problem I'm working on.
Bruce is next, the gentleman in the back.
Does this WRIA process and all the things that you just walked us through include all water sources, both surface and subterranean? Are we talking about all the water, or are we just limited to surface sources?
Well, that's a good question. I think most of the resources allocated over the last 14 years have gone to surface water. There's been some effort with groundwater. It's not adequate. It's a problem because there's probably an argument that when you go to court, if you haven't figured out groundwater, that the adjudication can't be comprehensive. And in that case, you might be defeated in your attempt to invoke the McCarran Amendment and have it take place in state court. So it's a good question, an important one. There's starting to be some attention paid to that right now, but it's another major funding question. I know DOE has some money, but probably not enough.
Well, I guess as a follow-up then, does the Department of Ecology link the subterranean sources, groundwater sources, to this process, and has it been brought in and is part of the and particularly with the lawsuit and the federal lawsuit, does that include ground or subterranean sources?
Yeah, I question whether or not surface water, we have, how many, 230 independent little water associations in the county. And our water rights, even up on the hill on Ferndale, are now in jeopardy with Ferndale taking their water from the west.
I hear you.
It's a big issue.
It is. Getting back to this gentleman's question, I'm not sure I can give you a very authoritative answer to that. I think ecology's rules are going to cause problems if you haven't figured out the groundwater part of it, because there's generally or so often some kind of connection between surface and groundwater. And as to whether that's, I think it's maybe too early to say exactly how that would be represented in the tribe's issues that they're raising. I don't recall seeing it specifically addressed. That doesn't mean that it wouldn't be in the course of things.
Yes, no, maybe.
Yeah, something like, well, I think it's going to have to be there. That's what my opinion of it is that I think it's going to have to be there because the sources are connected to some degree, and that's why it's going to have to be brought out. It just hasn't, not enough attention has been paid to that yet.
Let's, actually, instead of going to the back to Elliot next. Okay.
Elliot, fine. What is your current source of funding and budget to tackle all of this?
Well, I don't have one. No, to give you a serious answer, Birch Bay Water and Sewer District pays my salary, and it's been seen over the last year, I'd say, that it was important for me to bring these issues up so that people understood them, and then see if we could use that as a way to marshal broader support and try to get joint funding. We still haven't got that going. That's what we've been trying to do. I'm saying to the county, they need to fund part of this. I mean, there are things they're the best situated funding agency that I know of. They have tax authority and other things they could do. And then we're also going to our state association. There's maybe 75 districts around the state that belong to an association, and we have supported legal efforts in litigation, big issues in the past. So we'll be talking to them about that.
And you made this presentation to the county?
Something like this.
I want to
Yeah.
Ellen's next, then Terry. Ellen?
Oh, well, I was just gonna say, are the water studies complete that WRIA has done so far, or are they moving ahead? They talked about this Utah state, that pretty much, they were looking at surface water only, or are they finished, or are they?
I don't think they're finished,
Could you
but I don't think what they
repeat the
have is
question?
adequate.
What was the question?
She was asking if the
Hydrology.
hydrologic and hydrogeologic studies were continuing, or do they consider them done? And I believe they're continuing.
Terry's next.
Terry Unger. In follow-up of what Bruce was mentioning, the state of Washington and the county health department has allowed catchment of rainwater in calculations of the household needs and meeting the minimum amount of water to supply a household. Has rainwater catchment entered into it? We're hearing rumbles that the Lummies are definitely going to challenge that too. Has that come into it from anywhere?
Well, it hasn't come across my desk. That doesn't mean it's not there. I don't know about it.
Sears next.
Yeah, I went to this Gateway Pacific Terminal hearing at Seaholm High School, and was just flabbergasted by the ridiculous bar that they put up. I guess we'd have to have the second coming of Christ to meet the requirements for a terminal to be put in. So what I'm concerned with is when you mention this 80% rule going to back historically for fish, I mean, this is insanity. How can we possibly meet a requirement, you know, when the fish were leaping into the boats? I mean, 80% of that. I mean, I'm just wondering, is there any common sense here, or if we get a really good sharp lawyer, is he going to be able to counter this, or she?
Well,
These ridiculous.
in my opinion, we should be realizing we should be trying to go to a general adjudication and make those issues have to be argued in court. You have to show a basis in the treaties to support that. The Bolt decision, the language in the Bolt decision gave the tribes fishing rights that were 50% of the catch, or an amount sufficient to support a modest living, whichever is less. That's why I said this is a lot more than either ESA or treaty fishing rights would seem to require. So I think court would sort that out. I would hope.
Gentlemen, are you a member for Zoom? Okay, I need to hold off on you until we get others. Chris is at his end. Which one? Riggs. Riggs is on this. Riggs. It's blocked.
Rich Nelson, this issue is very close. If you noticed on the news last night, the Stillaguamish tribe has gone to court to stop a bunch of development, which has already started. But the permits have been issued. This is homes that are in the Skagit River drainage. It covers, like the Point Elliott tree, which covers a whole lot of area. They have their building permits. They have their infrastructure, i.e. power. They have driveways. They have wells, water. The Stillaguamish tribe has gone to court to stop the development because of the water rights. That just happened just on the news last night. So, this is a statement. This is really coming closer than we all know about. And they've stopped it. They cannot build them.
Did you want to comment?
Oh, just to say I agree, as far as I know. Well, the parallel I draw from what little I know about the Skagit is that it's another example of a process where they excluded a lot of the interests from the process, and now that's coming back, and it's going seriously awry. They probably need to go to court. That's what I think.
Chris, did you ask a question before?
I have a quick question, and what I'm hearing you say is that you possibly would like most of us here to put some pressure on our county council to start dealing with this issue. Am I correct in that?
Well, I wasn't going to necessarily advocate. Draw your own conclusions.
And the other,
we have written them a letter saying you think you need to budget for specialized legal counsel and to reconvene the planning unit.
and the other thing is that when you talked about the 50% lifestyle, you know, for the tribes, the state has and the federal government have not brought in the gambling income that they're now getting that would completely offset any loss from their fishing.
I've read that language. You may be right.
Nada's dying to ask a question here.
Nada Deitch, member. We need solutions to this sort of thing, and I'm looking around the room. I am ignorant about what's been going on. I see the headlines in the paper, and I take the Herald, but it doesn't give me the information. I also take the Wall Street Journal and the Seattle Times. But anyway, we need to get people involved in this sort of thing with letter writing, and I'm looking around here at people that know how to write and give the background to this, because I didn't know anything about how this started, and that's what you need to do, is learn about how things start. Just like this Agenda 21 with the United Nations started with Woodrow Wilson. How many people know that kind of thing? This is what we need to do, and the Herald once told me that somebody could write a call if you want to use 700 words, and they will print it. That was for the members of the Northwest Business Club. So I think that we need to get more out, either vocally, meetings. People hate to go to meetings. I used to, and I don't anymore. But I want to know what's going on, and I want to help people correct these situations, because we're getting run over by these government entities. And I'm sick of it myself.
I'm going to take the question in the back because he's going to become our next member.
Yes.
I'm working on it. I really am. Just forget. I would like to thank you for this presentation. I also attended the one in August for the committee members, the resource committee. And I wanted to point out a couple things. Number one is at the last committee member meeting, it kind of dawned on them they weren't sure whether they were supposed to do something with this. They'd totally forgotten everything that had gone on. And I specifically remember you asking about the planning unit, and they were still out in left field. They didn't understand or remember what they were supposed to.
Last week, the Water Districts Caucus sent them a letter last week that said, among other things, here's what we think we need to do in the 2013 budget.
Well, that's probably good. Maybe that's why they brought it up again, because they finally remembered.
Maybe that jogged their memories.
But it's important that they just totally forgot. The real question I had is also at that last council meeting, it was brought up that there's been another ad hoc water rights group put together, and that the executive is financing this or backing it. I would just like to know what the value of that is, and you think it's worth doing rather than going back to the planning unit.
No, I don't think it's worth doing. I think it's a bad idea. It's something that the Puget Sound Partnership has fostered, and it does not include all of the interests who were originally there at the table. All it is, in my opinion, is an attempt to give the impression that what they're doing actually has broad community support. So they want to get a lot of people involved in a strictly advisory capacity. And that's just not going to cut it. I don't think we should participate. Well, we may want to participate in sort of a critical mode, but we don't want to validate that.
Bill in the back, and then Doug, and then we'll close it. No, wrong Bill, sorry. Behind you. There you go, there you go.
Sorry. Bill Henshaw, and I've been involved in this thing since the very beginning, peripherally, through the Land Use Caucus, BIA, Realtor. Way back when, that adjudication by the Yakima tribe was going on, and it was very clear it had been 17 years at that point in time and hadn't been resolved. And I suggested at that point that we need to get into adjudication right then rather than providing stacks of material that the tribes could use as ammunition in their lawsuit, because it was obvious that that's what was going to happen. I think the best thing we can do is to get the county off their hind end and get them going on this and get into court as fast as possible, because it's going to be at least another 17 years before this gets resolved.
We should have put you in charge of this back then, Bill. You were right.
Doug.
Doug Smith. One of the past county council members, Marlene Dawson, has spent, I think, the last decade researching Indian water rights laws, and I think recently got involved with something having to do with water rights out on Sandy Point. Have you consulted with her? Do you know of her work?
She's been in touch with me by email, and she sends me things that are intriguing. And what I've told her is I can't really work on this right now, and the reason is I'm just one person and I have my job to do, and I've got to balance that with all the other things I have to do. What I'm trying to do is what I said earlier, is I'm trying to work the organization angles to get resources brought in that will enable us to hire highly qualified attorneys to deal with this. That's what I'm trying to do is add resources. I can't really do that myself, is what I'm saying.
So is your recommendation then that the county council needs to be encouraged to get off the dime and get involved to the extent that funding can be arranged to protect the community's interests?
Yes.
Okay.
I've recommended that directly to them a couple of times.
Okay, last burning question. Who funds the Puget Sound Partnership?
There you go.
Well, they get a little bit of state funding, but the most straightforward answer is I don't completely know, but I know somebody who's trying to find out. I think the other thing that's going on is that there is a flow of federal money coming by way of EPA, and I'm not sure exactly how it gets there. In other words, does it go through the regular state appropriation process, or is it going around that somehow, and then how much is it?
We'll let Bill have a very last
word. I don't know.
Question of prospective solutions. In major resource disputes, it always comes down to either control of the resource or monetary payment. We have parallel in the city of Tacoma when there was tribal disputes around land ownership in '88 resolved by the state, and then paid multi-million dollars to the state and local to resolve that tribal interest. My question here is, and it's not your opinion but observations, do you see this as prospective solutions, that is the drive, the inertia is more towards controlling the resource, so therefore it has a valve on the amount of water that can be utilized, which ultimately would degenerate the development scenario in this county, or alternatively, you see this as simply a drive to create some sort of monetary source that is a royalty on each gallon that is consumed by us that's paid to the tribes?
Probably the latter, if I had to choose. That would be my guess. I don't have any solid basis for saying that. It's just kind of what I think.
How about a big round of applause for our speaker?